we are here with Kirby Clements, attorney at law. We met about a decade ago at CNN when they had the show HLN After Dark, and we've been friends ever since. I'm gonna let Kirby tell you more about himself, but great guy. Thank you for joining me today. And before he introduces himself, we are going to be, he is currently a defense attorney. And we're going to be talking about next steps for Jonathan Majors in terms of what he could possibly do to not only remedy this conviction, but maybe even, you know, in the future from a post-conviction standpoint, what he can, you know, do to kind of save himself. Because honestly, these charges and what he was convicted of shouldn't be anything to destroy someone's career, but you know, you're only as good as your last mistake in America. So we're going to just go with that. And Kirby, go ahead and introduce yourself and let everybody know your background.
All right. Well, my background is I'm a criminal defense attorney now. I used to be a prosecutor. I started out in Georgia, and I prosecuted felonies, misdemeanors, and even done death penalty work, and then became an appellate lawyer as a prosecutor. Then I moved to Brooklyn so my wife could go to med school. And so I was a prosecutor in the Brooklyn DA's office. I was in the sex crimes and special victims unit, and then in a specialized trial unit dealing with school crimes and juveniles charged as adults. Then I came back to Georgia and went into practice with my sister. So we do personal injury, car accidents, and then I do all of the criminal defense. I do all the trials. If it's a trial, I'm doing it. If it's an appeal, I'm doing it. But if it's criminal, I'm doing it. But she handles all the other stuff, the personal injury, the med mal, all of that. And there you go. Went to Emory Law School or Roberts University undergrad. I was a Division I discus thrower and shot putter, believe it or not.
Nice. Well, you have the stature for it. So they always want the tall guys with the, you know, the big bills to do that discus. Okay, so as you guys see, this guy has a breadth of knowledge. So he understands injury. He understands the criminal aspect of injury. As a DA, he understands prosecution, a former DA. He understands prosecution. As a criminal defense attorney, he clearly understands defending those accused of crimes. So he is the purple unicorn of the legal profession. And he can basically give expertise on everything that was involved in this trial. So I guess basically what I want to kind of touch on is from a defense standpoint, from a defense strategy standpoint, because like I said, I feel like they did what they could do without opening the door to more prejudicial evidence. And we discussed earlier, like there was a lot of stuff that was not considered evidence that was presented to the jury for background information. So right. I guess discuss that a little bit more, explain to my viewers how that works. How does that even happen? How do we get 7 hours worth of testimony that's not even evidence as background information in an alleged domestic violence situation?
Well, I will tell it to you this way. I'm going to start with something not domestic violence and then move to domestic violence. Take you get robbed on the street. That's a one-time event by some stranger who comes to rob you. You never met him before, so there's nothing really coming in. But let's suppose that stranger robs you and they're wearing a clown suit. You tell the police, this guy robbed me, wore a clown suit. At the trial, the prosecution might introduce all the other incidences where this person wore a clown suit to say, this is the same guy because he's the clown suit robber, if you will. That just goes to show his modus operandi, his MO. In a domestic violence situation, it's a little bit different, meaning the status of feelings and relationship between the parties is important, because if there is a history of domestic violence, which oftentimes happens behind closed doors and no one knows about it, and I'll give you this classic example. The woman and the man have been married for 15 years. He's been beating her for 15 years, but she's never called the police. And then one day he knocks her down, she hits her head, and she's unconscious, and the police get called and they investigate it, and then she discloses, he's been beating me for 15 years, but this is the first time he's ever knocked me unconscious. Well, they're going to allow that evidence to come in of the 15-year, well, not all of it, but they're going to really scrutinize how much of that 15-year abuse history gets to come in to show the status of the relationship between the parties, to show the feelings between the parties, to show how they deal with each other, to also explain why, her conduct, because people are going to want to know, you never called the cops. Well, I got 15 years of not calling the cops. Plus, I didn't call them this time. My kids called them. So that's why you introduce it, to kind of put things in perspective. What you cannot do is to say this person committed crimes and therefore they are the type of person who will commit crimes. They have a propensity to commit crimes. So in the example of the clown guy, you can't bring out the fact that the clown guy sold dope, sold cocaine, and done a bunch of other stuff, because it's like, well, what does it have to do with him wearing a clown outfit and robbing somebody? It has nothing to do with it. So that wouldn't come in. And then the same in the domestic violence thing. Don't bring out the fact that the guy has 15 other kids by 15 different women or whatever. That doesn't matter. Or he's robbing, or he has a drug problem. Doesn't matter. So it's very limited, and the court has to give a limiting instruction, which this judge did. But that's the only reason it comes in.
But the limiting instruction wasn't, to me, limited enough, because I'm like, okay, why are we talking about him threatening suicide? Like, what does that have to do with it? There was a lot of digs that I feel like were thrown in there to kind of almost embarrass him more than it was providing any context to how their relationship was. You know what I mean? So, you bring up that, he threatened to commit suicide, even though she told it in the context of as if it was happening every time they had an argument. You bring up that he got upset because you came home drunk. He should get upset because you come home drunk in front of his trainer who he's working with on a professional level. That's embarrassing, like things like that. To me, I feel like you were just trying to make him out to be a bully, and not so much as you were trying to, like you said, establish their, relationship, how the relationship went or was going. I feel like a lot of going off road instead of sticking to the course that we were trying to stay on.
But you said something very cool, very key. Sorry about that. I hit my camera. Mm-hmm. Sorry, cameraman. But that part where you said make it look like a bully, that is indeed the point that they were trying to do, is to say, look, I'm just telling you from a defense side, you hate it when it comes in, because you're like, everyone's going to hear this in the context of a crime, meaning you're alleging that that this person committed a crime on this date. And so when they're bringing out this other stuff, you're thinking, oh, well, that must also be crime stuff as well. When he wasn't convicted of that stuff, the fact that he was upset with her coming home, now they're trying to say, this shows you he has a temper. This shows you he's controlling. And that's the argument that they're going to make. But as you indicated, well, no, it's not controlling to say, don't come to the house drunk when I have people. And
bringing your drunk friends with you when I'm with my colleagues. Right.
Exactly. That's going to cause an argument no matter who you are.
No matter who you are.
The idea that he threatened to commit suicide. Okay, yeah, he may have done that. And yeah, both of y'all are subject to histrionics, but he didn't say he was going to kill himself if you didn't give him his phone back that night. So why you're introducing that? But again, and that to me would be a good basis for appeal, I think, to say that, because when you introduce those prior, we'll call it prior bad acts, right? Or uncharged, they call it uncharged crimes in New York. When you're introducing those prior uncharged crimes, one should be crimes, but two, you got to factor in whether the prejudicial value outweighs the probative value. Well, what I mean by that is it may be probative or pretend to prove some facet of this case. That is good to know. That does make me believe this. So that's probative. But does the prejudicial value of that outweigh the probative value such that we can say, now you put in too much of this stuff or the wrong kind of stuff, so that now the jury's they're going to convict me of this, not based on this. They're convicting me of this based really exclusively on that, because they now go, he's a bad guy, he's a monster, he's controlling, he's evil. I don't care if he did this that he's charged with. We know he did something at some point in time, so we're fine convicting him now. And that is the basis of the appeal here.
And that's what I'm feeling. This is a terrible example, but it's the only one that most people remember. OJ. I personally believe he did it. Okay, but he didn't get convicted of it, right? But Then fast forward X number of years, he gets 8 years for stealing his own stuff, you know? So it's kind of like you're paying for something that you did before in a current crime that you're being.
And I should say, I say he did it. I should say, I believe he did it because I watched that trial. I was a
I
prosecutor.
watched the trial. That was my first year at John Jay College of Criminal Justice. My first year, I was a freshman at John Jay, and I watched that every day after school. We didn't have cable in the Bronx at that point, so it came on regular TV, and I watched it every day. And I 100% believed he did it when I was 18, and I believe it now, and I'm not telling you how old I am. But
I'll tell you this. I'm about to age another year in a couple of days, but I'll tell you, I listened to Marcia Clark's closing, and because obviously I was working, but I watched it. I was talking about it amongst other prosecutors in the office, the DA's office, and we believed he was guilty. But Marcia Clark's closing, it covered a lot of stuff. But the key point is, there's always that one little piece that can turn the jury's mind. And in Mr. Major's case, there might have been that one thing that made the jury go, you know what, we're going to find you guilty. And it could have been, in my opinion, some of that prior uncharged criminal conduct, or and maybe not even uncharged criminal conduct, because we can't ignore
personality, bad personality, or oh, he has an ego. I mean, he could have an ego, like we all have an ego to an extent.
Or just two, as my dad likes to say. My dad's is an archbishop and a dentist too, but he talks about this. You got two selfish people coming together, and there's going to be conflict. He has to be the kind of person he is, because it does take a lot of hubris and a lot of ego to think that you can become an actor amongst all these thousands of starving, millions, how many actors there are out there. You have risen to that level, and you now have to maintain that level and know that. So you got to have, it takes the same amount of hubris, in my opinion, to just run for public office, to be president. I am the best man for this time.
You have to be exceptional. Right.
And then you have to recognize that. You can't just be like the old all shucks guy. No, you got to really believe that you are that you are him, as they say.
And he was. I mean, but for all intents and purposes, for me, I love me a cocky, not disrespectful, but I love me a confident. You say that. You're a great man. You are. You're a great man.
But now she was also selfish and a drunk, because she wanted that lifestyle. She wanted all that came along with it. She wanted to be with that guy.
But didn't want to behave appropriately.
Exactly. At the same level, if you want to be on this stage where the paparazzi are always around, you got to understand, if you bring dirt to the events that I'm at, that dirt sticks to me. Jonathan Majors, girlfriend, drunk at a party. That's going to make me look bad. People are going to question my decision-making process.
Right.
So, but the fact remains, she's doing that. So she also has her dysfunction there. And you're going to have function. They probably had great, splendid, loving times together. But you're going to have, when things don't go well, they really don't go well. But that's not the product of one guy being a bad person. It's the product of two people, when their weaknesses come into contact with each other, boom, sparks happen. Not the good sparks, I might say.
And that's literally what this boils down to. Toxic relationship. Everybody's had one, some more than others. I can't say that I've really had one, but I get it. I've seen them. I've lived amongst them. And sometimes you just have to cut your losses. And unfortunately, he tried at least twice to break up with her before March 25th, 2023. That was just the nail in the coffin that day. But he did try to break up with her. He tried to break up with her the day after that voice recording was made and that text was sent. So it's not like March 25th, 2023 was the first time. It was the final time. And I think that finality is what sent her over the edge, knowing that, oh, wait a minute, he's serious this time, so what am I going to do? What am I going to say?
Well, and the text, because at that point, it's not just that the relationship ends, it's that the relationship has ended, but you clearly have found someone else who could, in theory, be better. Some woman says she's wishing she was kissing you right now, so you've replaced me. And, that's the one thing. People can break up and go their separate ways, and you think everything is good, but then let one of them find out the other one's in a relationship. Then suddenly it's like, what happened, man? Now you going by, you call it. Yeah, it's like, no, this person is entitled to live their life. So I think that is that aspect of it happened here, where you had those two people there, and that came into being, which is why I see why it might be better. You know, she might be a business for me to go into, the breakup business, where you literally hire your lawyer. You gotta hire a lawyer if you're an actor to break up with somebody. Like, hey,
make them sign an NDA. Yeah.
Thank you. It's like being
get all your stuff back. Get your phone, your Rolex. Restraining orders.
The whole nine. You're out. And I need you to sign this form. I will send your stuff to you. What do you think is yours in this apartment? All right. We'll put a tab on it and
do an inventory. Yeah.
And
you're in Atlanta. You're in the.
Yeah, exactly. And the actor is somewhere else. Like, I can't believe you broke up. It doesn't matter how we broke up, because we were breaking up. You know, that's the point.
Right.
Now, in a relationship, you don't have your lawyer come and present your side of the story or your argument in a relationship, because we're together. But when it's over, there's no need. I mean, there's no good way to get fired. You know what I'm saying?
There's not.
The job of girlfriend. And so that might be the way to do it, is to just have somebody come in, inventory it, be like, nope, officially you're blocked. Here's a letter, no more phone calls. You insulate your client so that if anything does happen down the line, they can you can say, hey, look, you had a letter that told you not to come around. Why were you around?
Right. You know? Look, we just developed a new niche. I could be your paralegal. Look at that.
Absolutely. We just go around. We are the breakup specialists. Here's your letter.
The breakup specialist.
Yeah, absolutely.
And you're in the reality you're in the reality TV capital of America. So you got Tyler Perry Studios, and you got all the reality shows. So we can make some money on that.
The real breakup is in Atlanta.
Yeah, right. Exactly. Right. But I mean, we're joking, but like that's something to really consider, because it just seems like, even with the Amber Heard situation, it just seems like you can't break up with certain people or else they're going to like destroy your life. I mean, we're oversimplifying it, but this is literally what it boils down to: a breakup gone wrong.
And a DA's office who did some things I disapprove of.
Right.
Because I don't know.
You're breaking up a little bit.
And that's something I didn't mention it when we were talking before, but think about this. The DA lied on the police to gather the evidence to try Jonathan Majors. But the DA rejected the police when they said, we think she should be charged as well. And they're like, well, we're not going to rely on you now. Why did you make that selection? Because if the police were thorough and did a good investigation against him, then they were equally as thorough and did a great investigation against her. So why did you just decline to prosecute? And I'll tell you the answer. The answer is Fifth Amendment privilege. And what I mean by that is, when the defendant has a claim against the victim and the victim has a claim against the defendant, now both of them have to really think, do I want to pursue my claim knowing full well that what I say could be used against me in another prosecution? Each side says, no, I don't want to risk getting convicted. They both invoke their Fifth Amendment, and everybody goes away. That happens regularly. But here the DA said, we're not even going to give y'all that option. We are going to make an election to dismiss and not even charge her, despite the fact that the police department, upon whom we are relying, has told us she should be charged. And I have a problem with that, because I have a problem with.
I have a big problem. So
what was the math behind that?
Well, the defense alluded to it, but it got objected to and sustained. But the defense did ask, is it because you're cooperating with the prosecution? It got objected and sustained, but we heard it, and we kind of all feel that way. But is that appealable? Is that something that's appealable? Because wouldn't that go under abuse of discretion, or I don't know. Like,
well, I think it depends on how much was excluded out. Meaning that if you want to say that it was because they were cooperating with the prosecution, I mean, obviously there's two things going on here. One is she could not be held responsible for the decisions of the DA's office. So we can't say to her, well, isn't it the fact that they're not prosecuting you, and then it's like it's all because of you that they made a decision? Well, she's not responsible for their decision-making process. But what should have been allowed,
responsible for cooperating now.
Well, she's responsible for cooperating, and I would have wanted to know how much conversation went in about the charges that she was charged. Did they ask you questions about what you did? Did anyone vet this? Because I want to know, did the DA cover its ears and only open them up when she was talking about him? So there's a way to bring it about where you still have the argument. In other words, she's not going to tell the jury the DA loves me and picked me, but you're going to be able to bring out what the DA didn't do relative to her, what she did do. And then at the end, in closing argument, then you connect the dots. What's going on here? The DA made a preference, but she's just as guilty as he is. If he's guilty, she's guilty. But if she's sitting here not
mutual combat.
Exactly. You got mutual combat. You got a variety of, I still think there was justification and some other issues that were there too, but I think
go into that. Explain that, because I was not on it. I was watching someone else's YouTube live on the issue, and we had a troll in the comments that's basically saying that you cannot defend yourself, you cannot try to retrieve your property if it's taken from you, that you're not allowed to she used the word assault somebody to defend yourself or get your property back, when that's not true. There's actually a law that says that you are in your rights to defend your person, your property, or someone else's person and property. Obviously within the law. You can't kill somebody. You can't use deadly force. But you can. And if it ends up that you have to smack the person to get your phone back, then, because they are the aggressor. They snatched your hand and your phone. So at that point, you can get your phone back, however that works.
Right. And now there is a certain duty. There's a duty to retreat, I think it is. Or fine, but let's move beyond that, because this wasn't that scenario. This is an ongoing, you taking my phone, I don't have to release it. And I think in terms of how the case went, overall, I will tell you that sometimes you gotta make, it's one of three choices you gotta make. You either gotta say, I'm away from this. This had nothing to do with me. And you just remove it. You're just drifting, going away. You're putting yourself outside of the zone of danger. That's alibi. I wasn't there. You're just really running away from the facts because you have no connection to them. Or I was merely present. I was just there when this happened. Doesn't apply here. You can try to maintain the status quo. Yeah, I was there. She tried to get my phone. I resisted getting my phone, but I didn't do anything. Any improper things, and I'm just kind of hold. So what you see is what happened, and you're just holding there. But in this instance, we know that they were bringing in those prior events. So at that point, you're going to have to rush in. You got to go into the storm, and you're going to have to admit some stuff that you may not want to admit because that make you look good. But you got to own this. If it's going to come in, it's going to come in. And people you don't know are going to be making a decision. So you may as well be like, I'm going to presume you guys are going to look at this negatively. So let me rush in. Let me go ahead and acknowledge some of the bad stuff that I have done. But let me also recognize this. To the extent that she got hurt and you believe the injuries occurred in this car, and that's the key point, you believe they occurred here, that was her active participation. And so he was charged with the reckless element in his charge. So I wasn't reckless. I was very deliberate in what I was doing. She was just out of control. I can't help it that you acted a fool and got hurt. And your injuries, your fracture may have come from your misconduct. Your cut on your ear may have come from your misconduct if we are concluding that it happened here. And kind of my way of thinking as a defense lawyer is I would have created two different scenarios for the purposes of reasonable doubt, which is to say, I don't know when she got hurt. I just didn't hurt her. Now, whether she got hurt in the car in the course of that struggle, and where she was trying to take my phone and she was attacking me and I was keeping her from me, if she got hurt in that situation.
Or grabbing your jacket when she got out the car, when she grabbed his coat.
Right. There are several times where she could have injured herself or gotten injured, not as a result of any recklessness on my part, just me just extricating myself. Because there's no obligation for me to submit to her aggression.
To you jumping on me and pulling on me.
Exactly. Or did she get hurt when she was at the club, drinking and all this other stuff? Or did she get hurt when she was back in my apartment where she wasn't supposed to be because we were breaking up and she's locking herself in the room and I can't get her to answer the phone and we know she's on the phone during the time I'm calling the cops. And so we see all this happening. Did she get injured then? Did she cut herself behind the ear? Did she stumble? Because we got to match it to the medical testimony. And they said if I hit her, there should be a bruise. There's no bruise. So that obviously wasn't a hit, caused laceration. Could have been caused by something else. Again, I don't know. But if I don't know, and she can't necessarily give it to you, you can't.
The doctors don't know.
The doctors don't know. Nobody knows. You all just can't reach the conclusion it must have happened here. And then as to the finger, again, did she where it was the lateral fracture on her finger? Did she get it in the room? Did she follow up the steps getting it because she was drunk? She's admitted being drunk. Did it happen at the club?
Because her hand got caught in my jacket that she ripped all the buttons off of? She grabbed them 2 different times.
And the reason that she didn't notice that she wasn't wincing in pain is because her feelings may have been a little dull because, like how they used to take bullets out in the cowboy days. You got enough alcohol in you, you'll feel it when you wake up, but you may not feel it right now. So there are so I would give several. I would have created several different places for those injuries to have occurred. Each one just as believable as the one that we are on trial for, and then let the jury know. And I've been doing this of late. In a criminal case, you're not called upon to weigh the evidence. You're not balancing, do I believe this one more? That's not criminal law. That's civil. Car wrecks. Who I believe. Criminal, the prosecution has the burden of proof. And they have to not only prove what they say, but these equally plausible scenarios, they got to disprove it. It couldn't have happened when she grabbed his jacket because, and give me some reasons. It couldn't have happened when she grabbed his phone and was assaulting him because, and it couldn't have happened when she was back at the house or in the bathroom when she was drunk because. If you haven't disproved those things, all of which are equally plausible, he's not guilty. And you don't have to pick between these scenarios. I don't even got to know the scenario is true. I just got to tell you it could have happened to any one of those, but it definitely didn't happen here. And that's the point. So you got to give the jury not just a why, but a why not and a how come.
And that's the thing. They didn't do it in exactly the way that you're saying, but all of those possibilities were presented by the defense. And the expert testimonies of both the defense and the prosecution's board-certified emergency room physicians did that. And still, I'm like, what?
Well, that's what I'm saying. But follow me. Well, two things. One, on that point, you have to, when you can lead a horse to water. When I teach trial techniques, I used to tell my prosecutors this. You can, not only do you lead you can lead a horse to water, but you can't make him drink. We've all heard that. My motto was, you lead a horse to water and then you drown him. And what I'm meaning by that is you're going to put their head in the water. So you got to clinch that point. As to the medical testimony. So doctor, are you telling me to a reasonable degree of scientific certainty that you can't tell me that her finger was broken in that car? No, I can't tell you that. And so, and you just start hit those things. The prosecution will come back with their rebuttal, but the fact remains it's out there. And I've drowned that horse. I've got you to say, I don't know that it happened then. I don't know that it happened then. It could have happened there. I'm going to give you different scenarios that we see from the evidence that happened, and we'll go through each one of those, and you tell me, could it have happened there? And then I'll even go a step further. If my client, look at my client's hand, because the jury, this is the other part of my point. A large black man, smaller white woman, allegation of physical violence. All right. Are you going to believe that? I mean, it just goes to men in general. Because, you got women will jump on a man and hit a man, and the man push her off. Oh, you hurt her. And I'm like I told you when we were talking about the other day, I'm big. So if you hit me and I push you back, I guarantee you, I may not move that much when you hit me, but you're going to definitely move when I hit you back. Not because I'm trying to make you move, but I'm 265 pounds for it. So when I hit you.
And you're like 6'4", like, of course.
Yeah, I can't hold back. I mean, I'm not even trying to hurt you. I'm just doing just being me.
Which your body does, right?
Exactly. There's no be gentle when you're fighting people off. But with men and you're fighting off a woman, it's like women aren't like children. My 5-year-old granddaughter comes at me. I can hold her literally up while she's mad. But a grown woman, 100-some pounds coming at you, that's a grown person fighting at you and coming. You're not going to just overpower them like you're some bear and they're a child. Yeah. No, it's going to actually be a struggle. One that the bigger one will win, but it's a struggle where injuries can occur. But the question becomes,
mutual combat is totally feasible. Right.
Who's responsible? But in this scenario, you got this larger black man with this smaller white woman. Then you bring out this, he threatened to kill himself. But what you never told me was that he was beating you up left and right. Sometimes, and in closing is when you kind of go into that. You don't bring it up during the trial. But in closing, you start going through, well, then she should have had her butt kicked. I mean, there should be no doubt that this man with these big old, because he's got I don't have fat fingers, but He got some
He's
fat
a big
hands.
guy. He's a big
I'm
guy.
like, so.
I'm 5'8" with my shoes 5'11", and he still had about 1.5 inches on me. And the one thing that I wish the defense would have objected to, because they did ask her, not the defense, but the prosecution, I can't remember the exact line of questioning, but it did get to the point where she gave us her stats. So she said, I'm 5'7" and 120 pounds. I don't remember what the questioning was, but then they asked, well, what's his? Oh, he's 6'2" and double my weight. Absolutely not. That man is 6 feet solid and 200 pounds. How did you get 6'2" and 240? I would objected to that, because now you're making him sound like some big monster compared to your 5'7". You know, and that, I'm sure that's stuck in the jury's head too, because most people that are not tall don't really pay attention to height, and most of those jurors were shorter than me or just my height. So if you're not a tall person, I pay attention to height, because being a taller woman, you know, you typically look for a taller man, right? Because you don't want to tower over your boyfriend. So me, I'm very aware of height and weight when I look at men. So I can usually instantly tell a height and weight just by first glance. And for her to sit there and double his weight, well, no, she gave him an extra 40 pounds and an extra 2 inches. You know, that's significant to someone that's short. So it's like, whoa, yeah, this is a big guy, and he threw this girl back in the car. You know, so I'm like, I was surprised that the defense didn't say objection. That's not, you know, that's not accurate information. He's not this tall. He's not this heavy. You know what I mean? To kind of,
it could have come in without, it wouldn't have been objectionable, because it would have been her opinion. But then what you do is you bring in his actual stats. How tall? How tall is he? You know, how much does he weigh? Has he ever weighed? And you can argue that she's exaggerating, but then you can also go through with the police officers and ask them, have they ever been in a struggle with women? And you can argue things that jurors have seen. You got 5 cops taking one woman down. You know, it was just recently, one cop is punching a woman in the leg repeatedly. They're punching women and fighting them, and they say we have to do these techniques to subdue them. And so you could have used those officers to show that just because she's a woman
doesn't mean she's not strong or can't fight.
Doesn't mean it doesn't take. How many times have you had to take that? We have to group tackle a woman. So it takes a bunch of y'all to take down one woman, right? Yeah, we've seen, and you just kind of go through it and you can talk to it. And in closing, we've seen the videos. Are we thinking that, and we all go, the person should have submitted to the police. The person should have resisted the police. That's the common answer. But why were there 5 male cops on this one woman? Because that one woman, even though she's a woman and smaller than all those cops and not trained, has the ability to physically resist. And in that situation, it isn't, your size don't matter. It's the size of the fight in the dog at that point. And that dog had a fight in him.
And my grandmother used to always joke. She used to say, you got to kill crazy people, because once they get going, you can't stop them, you know? She would say it facetiously, but, you know, once they get going and that adrenaline gets going, it doesn't matter how big they are. Some people have superhuman strength when you got adrenaline and crazy working hand in hand. I feel like this was the case, because anytime you can run 5 blocks in 30-degree weather, and we all know, those of us who are not cardiovascularly fit, 33-degree weather will burn a hole through your lungs. And she was running full speed for 5 blocks. That was adrenaline and crazy at a crossroads. Wow. And attacked him twice. She admitted to it twice, at least, at minimum, twice. So
that's right. That's right. But plus the fact that she chased him 5 blocks. And again, those are things that I would go through and just kind of point out. And so you weren't charged with chasing him for 5 blocks, you know?
I can't remember what she was charged with.
Bring that out. You weren't charged for that?
Well, I think that was part of her charges, not specifically in those words. I can't remember. I don't know if it was mischief, criminal mischief or whatever, but again, it didn't stick. They erased it. She went in, they booked her, and then they let her out, dropped the charges, didn't prosecute.
Well, apparently the DA had told the police department on the front end, although they denied, saying that they told them they weren't going to prosecute. But the reality is, how are you going to have somebody pursuing somebody for 5 blocks, grabbing them and jumping on them? That's a crime in and of itself. We don't even got to argue on that. That's at least harassment.
It's not.
They made a decision. Right. You know what? I'll tell you what. If he had chased her for those blocks, doing the same thing to her, it would have been a charge. So that's my point. Yeah. We want to be fair. We want to be equitable. Tell me that wouldn't have been a charge if the roles had been reversed. And if you can't tell me that, then you've already made a preference. And my question is, why did you make the preference that you made?
And then how about him sending her the breakup text and she still called him 32 times? She admitted to calling him 32 times.
That is harassment as well. Like, I'm breaking up. You're going to talk to me. And again, you can bring that up, and it all depends on. And I didn't get a chance to see the closing, but I would have hoped to have gone into that aspect. That just as you said, sometimes people just can't let go, and when they can't let go, they do some crazy stuff. And here we go.
How about him asking her to leave his keys, and she was still there 6-7 hours later? In the text message, she said, "Did you leave the keys?" Meaning, she said goodbye, Jonathan. He said goodbye, Grace. Did you leave the keys?
And the point is,
she was still in his apartment.
And they made a preference. Sorry about that. They made a preference as to who to charge, and that would be still something they kind of allude to. If the judge didn't let you get it all out, I would just go through and point out, and I would just say, hey, and I really would have drawn the line and been like, ain't a crime, ain't a crime, ain't a crime, ain't a crime. You know, her jumping on his back, not a crime. Him throwing her off his back, not a crime.
Not a crime.
Her grabbing his phone and in the car doing it, not a crime. Him resisting getting the phone, not a crime.
Not a crime.
And just keep going. And if you want to say crime, then what are we doing here? And just
parallel the behaviors. Right. Parallel the behaviors.
And then just parallel the whole history. What about these calls and all the things he said? Be Coretta and be whatever. I'd be like, hey, drunk. Everybody everybody got their foibles. Everybody has their flaws. And despite that fact, we can't ignore the fact that everybody has their foibles. Everybody has their flaws. But that doesn't make you criminal. And clearly, in this case, it didn't make her criminal. So obviously, it can make him criminal. So let's just start with that. And I'm just asking y'all for, I'm asking you for fairness. They're gonna charge you on the law, but the law that they're gonna charge you on is the same law that apparently she didn't break. So if she didn't break it, he didn't break it.
He didn't break it. Exactly.
Right.
Exactly.
So that would be kind of my thought. But let's just be real. You're a male charged with a violent act against females, and the statistics are 50% of women killed in America are killed by current or former romantic partners. Thus, because of that fact, the man is always going to get the negative look in a domestic violence scenario. Rightly or wrongly. I mean, obviously,
even if he's being abused as well.
Even if he's being, who's going to believe it?
On surveillance camera.
Yeah, not even then.
NYPD surveillance camera.
Right. If it happens to a man on camera, there must be a reason behind it. But if it happens to a woman by a man, we know it was a crime. That's how they go. And there's more to it. Don't get me caught up on the racial relations. We
already know what that is. But his defense attorney touched on that. She said that. She said it during closing. She said it during opening. And we already know what it was. The jury makeup was completely trash. I attribute it to, unfortunately, and I'll maintain this stance until the day the Lord decides to take me to glory. A lot of the problem in New York City, and I've witnessed this for myself, is that a lot of us don't like going to jury duty. I remember growing up and even into young adulthood, hearing grown people old enough to be my parents bragging about dodging jury duty. And I think that's a huge reason why a lot of our juries are not representative of us. And then a handful of us that do, and Priya, Jonathan's attorney, actually had a press conference about this, where there was one juror that was a Black master MBA, had his degree from NYU, and they did not pick him on a jury because they thought he would not understand jury instructions. How can an MBA from NYU not understand jury instructions?
Wait, who struck him? The prosecution?
Prosecution struck him from this jury.
And I certainly would have raised you have to, if you're raising a
well, she had a
challenge,
press conference about it, but I don't know what as a former DA, what are the rules in terms of how many jurors the prosecution can pick versus what the defense can pick? And is the judge the ultimate? Is he the one that says, "Oh no"? That's why I'm confused as to who's in bed with who, because the judge should have been like, "Nah, that doesn't even make sense. He has an advanced degree. He can understand jury instructions."
That is up to the. Well, let me explain this. It's not really jury selection; it's jury deselection. So you're just getting rid of people you don't want. So
right.
Let's say in a misdemeanor, it's been so long, it's been over 20 years since I struck a jury in New York. So I can't even remember now. And I only did felonies.
I feel like the corruption is still the same.
Well, yeah. Well, I'll say favoritism is always there. The behind the scenes work. But let's assume that the prosecution got 3 strikes and the defense got 3 strikes. It was going to be somewhere 2 or 3 strikes. Mm-hmm. But what happens, and then there's a strike, each one gets a strike for the alternate. And I don't remember the exact number of we call them peremptory strikes. You bring the jury panel in, the whole jury, and we call that the jury veneer. You then start asking questions of them. You make sure you have qualified jurors, and then you start individually asking questions. And then from that, you then start striking the jurors that you don't want. Do you want juror number 1? They'll give you the list. You'll say, no, that juror's gone. Then they'll pass it back and forth, and you're striking off. Now, let's call it a Batson challenge. If the defense believes the prosecution is engaged in a race-based strike, that is, you're striking all the blacks, or you use a disproportionate number of your strikes to strike otherwise qualified black jurors, they can raise a Batson challenge. And once they have established, because they got to meet the threshold matter. If you meet the threshold inquiry of whether your strikes are disproportionate as to African Americans who are already qualified, or any ethnic group, and then the burden shifts to the prosecution to come up with a race-neutral reason. If the defense doesn't ask those make that Batson challenge, then the prosecution never has to give a race-neutral reason. So my point in telling you that is that if the defense raised the Batson challenge based on the strikes and said that you struck that black juror for a basis that was not race-neutral, and the prosecution then says, well, no, I struck him because I didn't think they would understand jury instructions, at that point, the court can kind of go, well, that's a race-neutral reason, but I don't have to accept it because it's ludicrous. This guy's got an MBA, and
from NYU.
You're gonna tell me that this guy can't? I mean, as long as this person speaks English, and apparently they speak it well enough to get a degree from NYU, so you've already overcome that hurdle. What makes you think that? And so the judge could say, no, I want that juror. I reject your reason for striking that juror, and we're going to seat that juror so that juror gets seated, and the one that you put on gets, they got to go back. And now you got to decide, how do you want to do your strikes now? Because maybe you only had 1 strike left and you got rid of that juror. So it just factors into the striking process. But you never, ever even get to that point if you don't raise the Batson challenge. And you can have a press conference, but you got to raise that challenge. And if you don't, now obviously not raising it could be even under the fact, it could still be a reason for appeal, but I don't think but the argument would be you never raised it, so you waived it. And that would be
right. And so they did raise an issue with juror number 2. We're not going to get too much into the jury, but prosecution the raised a witness with an issue with juror number 2, only black person on the jury. She was a female in her 50s. I noticed almost since day 1 her falling asleep after lunch, heading toward adjournment time, around between 3 and 4 every day. She would start nodding off. So they raised an issue with her while the jury was not in the room, because 2 of them were running late. And so we were just basically waiting for the jury to come. And prosecution did raise an issue with her. I feel like they raised it because they felt like they were losing at that point, because everything else hadn't come out yet. The rest of the trial, we still had another 5 days left of the trial. Right. I think they just put it out there, but I feel like that could possibly work for the defense now, because she was falling asleep. She fell all the way asleep during the social worker's testimony, because it literally felt like a 5 p.m. psychology 101 lecture. All of us were falling asleep on that one.
And man, the jurors fall asleep all the time. jurors fall asleep all the time, and you either raise it or you just decide to ride with it. The prosecution raised it, but the juror didn't get struck. The defense was content to keep her there. And then also the question becomes, who's your alternate going to be? You know what I mean?
Well, there were two. There were, right. The two alternates that I don't know why when I do the peace sign, these balloons come up, but okay. There's something with this program. Whenever I do the peace sign, balloons come up. I'm like, okay. But the two alternates was a biracial Asian guy. I feel like he might have been Caucasian and Asian, and an older, she looked Mediterranean. I couldn't put a finger on what, but she was a darker color. So she could have been South Italian, maybe Middle Eastern, some kind of Hispanic, but she wasn't white. So those were the alternates.
But see, that's what I'm saying. The defense could have been, I don't want them. And the prosecution.
Because now there's no black people, right?
Well, not just no black people, because black people will still convict. But the question becomes, you're making it. I look at it like this. I had to go a little bit deeper than skin, although not all the time. Sometimes you got to just stop there. But you got to look at what underlying values and beliefs do you think that somebody's going to bring from their background. And so you got to ask questions in jury selection that kind of let you know. Well, not even let you know, they kind of hint to you. I mean, you're basically trying to reach conclusions about how someone's going to receive the evidence and think it through based on answers to questions that can include, hey, do you believe me? You can't do that. You can't be like, hey, would you agree with me that you can't ask any question like that. So it's like, educate them. You know what evidence is and tell you the types of evidence they're going to be in this case. Can you be fair and impartial? Now, what a lot of people do is ask, can you be fair and impartial? I like to go the extra question and say, well, I know everyone says they can be fair and impartial. My question is, because my client is charged with a crime, are we starting out in a hole? I mean, you're going to be fair. Once the judge says go and the evidence starts coming, you're going to be fair. You're not going to favor one side or the other. But just because we're the defendant, are we already kind of in a hole? You're going to be fair moving on, but we're in the hole. We're kind of behind. And the people who say they were fair, their hands go up again and go, yeah, you are in a hole because you're the prosecution. Great. Off you go. And so once that happens, you can get rid of them. So and then there are other questions you can ask, but maybe the defense felt, I don't want that biracial Asian guy or that Mediterranean woman. I'd rather have the sleepy black woman based on the questions that I heard. And the prosecution may have been, and they may have thought, we think that they'll convict more than she will, when in fact she convicted. And it also determines she convicted reluctantly. What kind of personality they have.
Yeah, I think she convicted reluctantly because when they polled the jurors, her and the she's 2 and 4 had to repeat their answer, because it was almost like, yeah, and then it was like, is that your verdict? And they had to repeat it, and then the second time 4 got a little louder, well, a lot louder. He's like, yes.
Yeah, well, now see on that one, I got you. I see where you're leading at, but it would depend on. I look more for the hesitation, because I know some people, they just talk quiet. They're like, "That's your verdict, yeah." Some people just.
The black lady definitely was hesitant, because I think they had. Well, I know they had already made their decision on charges 1 through 3. Charge 4, they sent a note before lunch asking to re-see the raw footage of when he tries to get her back in the car and she chases him. And they asked for a very small snippet of the testimony of the girl she went to the club with, the part where she says that Grace said that her finger hurt, but she did not recall seeing any injury. She did not recall seeing where Grace put the ice for her hand. Just that small snippet, completely out of context of everything else that witness said, where she says she never saw any injury. Grace never complained of any further injury. There was no injury behind her ear. You see all the surveillance indicating same. You see pictures that she took with that hand over someone's shoulder. No bruising, no black and blue. Forgetting all that.
I follow that, but I think what they were doing is they were trying to decide whether when he threw her in the car that she hit her finger then. And that's when she got injured. And so they were trying to come with a compromise verdict. And they were just like, look, I know she complained about the pain. And so all the other stuff is there, but the question is going to be, did she say to you that her finger hurt? Yes, she
Right.
did. Did she put ice on her finger? Yeah. All right. So then we know her finger was hurt then, and we feel confident in choosing the fracture was already there and didn't occur later. When did it occur? And they wanted to go back and look at their raw footage to kind of go, we think maybe it occurred then, which still to me dodges the question, can I put you in a car to get you off of me and to make sure you get somewhere safe?
And she testified that that's why he was doing it. They asked her, and she was like, he was trying to keep me from coming after him. He was trying to keep me in the car.
And that's what I'm saying is that I think I see how the jury was working through it, and I think that because, and this is one thing I don't like about juries as a defense lawyer, but I love about juries as a prosecutor, which is a lot of times they're trying to figure out how to make the charge. Some figure out, we just want to know what happened, and we just thought there was a gap. But usually what juries do is they're kind of going, all right, we didn't end up here for nothing. There's a reason we're here. So there's a reason these charges exist. So let's just see how we can figure out what really happened. And we're watching this video. So that's kind of what I think this is what happened. And the problem is when they're doing that, if that's different than the theory that the prosecution put, and I tell them now, you're making it up. And if that's not what they proved and you're trying to figure something else out, that meant that they failed to prove their case. And you're now trying to find a way to make the defendant guilty of something else.
And that's exactly where I was going, because when they replayed it, juror number 3, which is, I thought he was Hispanic, but I'm leaning more towards South Italian as well, very dark. And you know the history between Italians and blacks in New York. He was going like this, like, and the black juror hung her head down. So I feel like she was the holdout on 4. Right. And once they played that video and she saw him nodding, because they might have been going at it with each other, he was like, and
now, the only question is, was she hung her head on the ice, or she hung her head on the putting him back in the car? Putting him back in the car.
The ice.
All right. Yeah, see, and that's the point, is that as I piece it together, I can see her saying, well, she had no injuries to her finger, and then that juror, and this is just me surmising how we got there, that juror saying, well, that may be true, but if she hit her finger and hurt her finger, we know that she did it if she put ice on it. If she just said, my finger hurts, we don't know. But if she asked for ice and put ice on her finger, then that means that finger was already hurt and she knew it was hurt. And so all this other movement doesn't mean her finger didn't hurt. Just meant she wasn't just doing one of these, oh, my finger hurts things.
Yeah.
It was hurt. And so I think that's where the momentum was going. But again, it fits within a narrative, and that's why you got to work to make sure the narrative is not he beat this woman and I can prove it to you how. The narrative has got to be, no, there was a fight, and if she's not guilty of a crime, he's not guilty. So you kind of got to develop not to say that the defense didn't do this, but you sort of got to develop a theme, and you got to create you got a theory of the case, and then jealousy, whatever. Then you got a theme. This theme is going to flow throughout, and you got to answer some questions. Why not? How come? And once you start answering those questions, then you help the jury go in the direction you want them to go, hopefully. But I can see that woman said she wasn't complaining about her finger, and he said no, she asked for ice, and then that was it. She asked for ice.
I would have held it down. I'd have held it down. I said, that's fine. She asked for ice, but did you not see her grabbing his coat and him yanking away? She hurt herself.
Right. And that's where the defense really needed. I'm not saying they didn't, but they needed to focus on was all the opportunities for her finger to be injured in the encounter up until that point. In other words, that's why I said it. Remember at the very beginning, you either got to go away, you try to hesitate around, maintain your orbit, or you got to go in. And so at that point, you just got to go in. You got to be like, you know what? Yeah, her finger probably did get hurt then, but she was grabbing onto my jacket and I snatched my arm, and or I snatched my coat or whatever, or that evidence comes out and you highlight that through questions. So he snatched away. He had snatched away forcefully. Yeah. I take it you grabbed his jacket hard. Yeah. So you were trying to hold on. Yeah. So could your finger have been hurt then? Did you feel pain in your finger then? Well, yeah.
And then there was a second time. There was a second time she grabbed his jacket when they got back in the car after she caught up to him.
Right.
And that's when she ripped all the buttons off his jacket. So her finger easily could have gotten caught in the buttonhole.
Exactly.
Because the way that it was just the tip of that one finger, to me, that's like a snag injury. Like you got it caught in something. Whether you caught it in a drawer, caught it in the buttonhole, caught it in the car door. It's one of those catch injuries. You know what I mean?
And that's what I'm saying is that you, when you have injuries, that's why you kind of got to go in. You got to give a reason for that to be. This is a thing that we see. So why is it, and when did it occur? And that's, so sometimes, and so I'm not saying the defense did a bad job. I'm just saying that sometimes you really have to get that micro and just be like, and I'll tell you, I had a case when my client was on video. My client actually attacked her daughter was being bullied. And so my client went to the school and taught him up.
Probably something I would do.
And it was on video. So it was very rough for me. But I will say this, because the more serious charge, that was the one we couldn't be convicted of. We were offered to plead guilty, but they wanted the higher charge. And I'm saying, well, my client loses certain things, we can't have it. And the prosecution wouldn't cut a deal. We were literally like, we'll take everything else you're offering, just not that one charge. And they were like, no. I'm like, well, we're gonna have to go to trial. So here's what happened. I saw her daughter also go in and kick the girl toward the face. And no, the daughter ran and swung at the girl and was swinging, and they were fighting. And then when the girl was on the ground, you see my client come in and kick her, but you can't see where my client's foot went. So my point was, when the girls were fighting initially, did you hit her in the face? Because I called the daughter. Did you hit her in the face? Yeah, I hit her in the face. Hit her in the mouth? Yeah, I hit her in the mouth. Now I have another possible cause for that
injury. The injuries to the mouth, right? And it's a juvenile, so she's gonna get away with it.
Yeah. So the jury found my client not guilty of the charge that we couldn't be. I mean, once they found out, I'm like, we offered to plead to this all for the last 3 months, but y'all had to give them what we were offering them, and that's fine. But my point is, you have to account for every injury that is there, or give a scenario where it could have occurred. Right. And ask that witness, did your fingers hurt then? When did you first notice finger pain? If they say they don't know, then you literally, as a testimony, get to go, so you could have hurt your finger when you grabbed them here. I mean, since you don't know.
Here's the gag. They did that. They did that. And her only answer was, I didn't feel any pain because of adrenaline. Well, why did you chase him if he did this, and this? All I was concerned about was who he was texting. They said, did your finger hurt then? Did your finger hurt?
No, I get that. What I'm saying is that all of that is fine, but then you just have to hammer it. I mean, and I have done this. I'm not saying that my way is the best way, although I think it is. But anyway, but you really got to go sometimes until the judge tells you to stop. Like, right. So you telling me that you grabbed this and it could have broke me, but your adrenaline was so high. So how long were you high on adrenaline? I was high. Right. In these videos, when you're wiping your ear and grabbing stuff, you didn't feel your finger then, did you? No, I did put some ice once you had a little time to calm down, right? Right. So really, we don't know when and where you got your finger hurt, do we? And if she's like, I don't, you leave it at that, and you tell the jury, if she don't know, you don't know. You can't know. You literally are just guessing. You are just guessing right now, and that's a waste of time. Not guilty. You don't gotta like guilty, but you gotta give me like guilty.
Right.
Now,
my Lord!
Look at the screen. I see the stuff.
Yeah. So these are the ones that I cherry picked because there's a long list of possible appeal reasons. I was just curious to know your thoughts on for this particular case. Juror misconduct. That's probably you're gonna have to prove that they watched footage and watch things when they were at home. I guess sleeping is not enough. Improper evidence.
Unless she was sleeping, even if it was enough, because the defense didn't raise it, they've waived it. You can't observe an error and not do anything to correct it and then complain about it later on. Because the court will say, you recognize it then, you could have fixed it then, you wanted to take your chances that it would bounce your way, and now you want to complain. And you can't do that. So that won't work.
Improper evidence. Would that background information stuff possibly qualify? Maybe specific parts of it?
Yes, I think that the background evidence is a good grounds, not a guaranteed, but a good grounds to challenge, meaning the key issue is whether the probative value outweighs the prejudice. That is, you put it in, it was probative, but what you put in or the way that it
highly
came in,
prejudicial.
It was not just highly, unduly prejudicial. Like the
Unduly
prejudice
prejudicial.
outweighed the probative, and if the prejudice outweighs the probative, we're done. It was unduly prejudicial, or you let too much in, or it didn't come in for the purposes that you articulated, or you told the jury to only consider it for these reasons, and that was an improper basis because the prosecution argued, or it was used for this reason. So with stuff like that, it comes in and it's great for the prosecution, but the burden is you better land where you said you were going to land with that one. If you said this comes in for reasons 1, 3, and 5, it better only come in for 1, 3, and 5.
1, 3, and 5, and not right.
And so that is right, very right for coming in for absolutely challenging. I'm not saying it would carry the day, but it is certainly right.
It's a good, yeah, but they'd have to be strategic in which parts of that background information was highly prejudicial.
Well, I would challenge the whole thing. I would just say the whole thing shouldn't have come. None of it should have come in. It was uncharged criminal conduct. It didn't even rise to whatever level. I mean, it wasn't similar. It didn't prove any element in this case, or it came in for an improper purpose. It came in for, let's say, 3 purposes, and it should only come in for 1. And you work with that way. So that's why I'm saying you got to make sure that one is very technical and where you land, and then you can win though. That's the key point. You can literally get a reversal by, hey, it came in for this, especially if the evidence is less than overwhelming. And in this instance, the evidence was not overwhelming. So because when you have a close case, if it's overwhelming evidence, and it sounds really crazy when you hear this, if the evidence is overwhelming, then the errors that the courts are usually willing to acquiesce, they're okay with. It's like harmless error. Like, yeah, that was wrong. It shouldn't have come in, but in light of all the overwhelming evidence of your guilt, it is doubtful that this is what swayed the jury. On the other hand, if the evidence is not overwhelming, if there are some real close things that we got to consider, the court would say, well, in this instance, that really did make a difference. And because it really did make a difference, we're going to give you a new trial because it shouldn't have come in for that purpose. It shouldn't have come in that way. And the evidence was less than overwhelming.
Okay, good. Now, prosecutorial misconduct, that would have to be gross misconduct. I don't know. I can't say where I saw any of that, other than failing to prosecute her when she basically committed the same crimes that he's being accused of. So I don't know if that could fall in that category, that they refused to prosecute her in favor of prosecuting him.
I think that, and this is something I have coming up on a case I have with different contexts, but it's the equal protection argument. And what I mean by that is the prosecution has the discretion to charge who they want to charge. And the equal protection standard hasn't really been thoroughly developed in the context of criminal law. And I see somebody just walking up right now. So hold on, let me just hit mute for a second. Excuse me.
Okay.
Well, never mind. So the prosecution they came up so slow, and then they didn't even ring the bell. They walked away. I like it.
Not more Christmas gifts.
Yeah, I like an Amazon driver who kind of halfway does their job.
Yeah, right. When you're on a call, right?
Yeah, like he didn't even see me. But to the point of the equal protection argument being that based on account of his gender or his sex as a man, and also on account of his race as a Black man, that the prosecution in a scenario with 2 equally situated parties, both engaging in criminal conduct, the prosecution opted to let the white person go and instead charge the Black person, where the evidence was the same and the decision that was made solely on the basis of race. And that might be in this context where the court would say, well, you know what? What's the remedy? You think you get a free pass to commit a crime because somebody else got a free pass? You're not gonna get that remedy. And we can't make the prosecution prosecute them. So the court might condemn it. The court might say, we find it highly questionable, highly distasteful. We abhor the decision, but if he committed a crime, he doesn't get the equal protection clause doesn't guarantee you a free pass to commit crimes or to say that we all got to go down. But it is still an argument, and I'd like to see how they work it through.
Especially because he was being assaulted as well, and she was the aggressor and admitted to being the aggressor. So I mean, if anything, we should both be in a hot seat. Either both let us both go or take us both in, but it shouldn't be one over the other. And that I think that
probably do statistics.
Statistics.
They can also do statistics to basically say it's not just my case. That's the key point. Not just my case. I'm saying overall.
This one, right.
Yeah, you all have a habit of charging black men against white women, or something that kind of shows this is a pattern of selective enforcement.
Right.
Of selective enforcement. Then we can do it. But again, the law is, I'll say it this way, because I've researched this topic extensively over the last several months. The Equal Protection Clause says you shall not, that no person shall be penalized basically on account of their race or any of the protected classes with the application of the law. But there's no, that always does good when you're talking about civil stuff, education,
right,
stuff like that. But once you get to crime, we're fine with it. Our courts will come up with a way, because you know what? I'm just telling you. Equal protection, it's unfair that you said that girls have to wear skirts and boys don't have to. Yeah, we think that's equal protection. Equal protection, blacks got to carry ID and whites don't. Equal protection. Equal protection that we prosecute black people but not white people. The court, I have yet to find a case, and I've been looking, trust me. I've yet to find one, even when the facts seem to be pretty straightforward. So no.
Same thing with stand your ground. Stand your ground. You know, black people stand their ground. We going to trial. White people stand their ground. Oh, you did what you were supposed to be doing.
I have two cases like that where, excuse me, where I mean literally standing video, my client calling the cops, and they're literally like, nope. So there is there is a double standard that is applied, and I'll say this, where you say it has occurred and the legitimacy of everything is it does not undermine the legitimacy of the prosecution. If it doesn't undermine that is, did you do what they say you did? Yeah, okay. We're not going to just say you get to walk away because America is racist or whatever. You know, that may be true, but you still broke the law. So it's got to be a little bit more. So that's why it's not going to get anywhere.
And so I would just throw abuse of discretion in there with the prosecutorial misconduct, because we kind of touched on both of those, because your discretion, you decided to do this one, but not that one. It can be construed as being abuse if, like you said, proven with all the other criteria.
But that goes to a selective prosecution claim that won't go. But abuse of discretion from the court is another issue. That is, if the court admitted those prior acts of uncharged crimes, that would be subject to necessarily to and I got to remember the standard, but basically, I know here in Georgia, the standard is abuse of discretion. The court abuses discretion in letting that in, and that's a different standard. So the standards of review is there. And then where you have legal error, this is the one, legal error is the huge one, and down here where it says prosecution intentionally misstated the law. These two are major ones that will result in a reversal if you can prove it. What I mean by that is, if the jury is charged on the wrong standard of law, you're going to get a reversal. If the burden was shifted in some way from the prosecution to the defense in what the court did in its jury charge, you're getting a new trial. If the court made some charging error or there was some impropriety in the underlining part of the case that we kind of go, we think, let me pause for a second and say this. Our overall thought process in our legal sense of justice is that we have a sense, due process is how much process are you due when we are evaluating whether to take your freedom in a criminal trial. And the theory is that so long as the process was done properly, then we believe the outcome was proper. So we don't pick a side. You might think your side was just and the other side is unjust. They might think the inverse, that they were just and you were unjust. We don't care. We don't care how noble your cause is. We don't care at all. We say that as long as the process was as close to perfect as it could be, not perfect, but as close as it could be, then we have confidence that the outcome was proper. So if they found you guilty and there was no breakdown in the law, they gave the proper charge on the law, and all those things were followed, then we believe the outcome was proper. So if legal error occurred in the jury charge, and jury charges are a big area that you really got to go through, even in the charge at the beginning when they charge in the jury, or the charge at the end when the jury's deliberating, those are the type errors that can get a reversal. If the prosecution misstates the law and the defense objected, then and that misstatement was not corrected by the court, then that is another basis. Like, hey, the prosecutor gave the jury a wrong statement of law, and the defense objected, judge, and you, rather than correcting them, you just let it go. And let's assume the defense said we asked for some curative, and it's not granted. That can be the basis where they say, hey, but that comes in as a error, and that more goes in another standard of error that, for which you want to claim. But there has to be a preservation of those errors by an objection.
Okay, how about this? Okay, so to that end, I'm going to share another thing, because us Twitter sleuths, we kind of figured this out. But again, I'm not an attorney. I'm just a paralegal. So that's why I have you here. All right. So you said, and I'm not going to hold you much longer because I know it's been a minute. But let me. I
got a little clock right here. Tell me how long it's been.
Yeah, it is. I see. Okay. So we got the New York harassment law, right?
Mm-hmm.
So this is number 4. He was found guilty of harassment in the 2nd degree. However, I don't know if I can zoom in on this. Let me see if I can. When the judge read the instructions or did the explanation of the charges, he did not. You see at the top where it says 2nd degree harassment. 2nd degree harassment occurs when he said this: with the intention to harass, annoy, or alarm a person, they strike another person or attempt to threaten or threaten to do so, follow a person in public places, act in a way that causes alarm or seriously annoys another person and serves no legitimate purpose. These two, he never said anything about. He stopped at strike another person or attempt to threaten to do so.
So that would mean that those other 2 portions were not, as long that they weren't charged, the jury didn't need to consider those.
Okay, but she did that to him. So I feel like if he would have said that, then it would have triggered in them like, well, he didn't follow. I feel like he should have read the whole thing. Like, I'm not understanding how you can cherry pick which part of the explanation of charges because then that means it doesn't apply. Because shouldn't all of that be read if this charge applies to the case at hand? How do you just decide not to say those 2 bullet points?
Because it depends on it. Because it says aggravated harassment occur in the 2nd degree occurs when, and it gives you those preambles, with intention to harass, annoy, or alarm a person, they do one of the following. You just put that phrase.
But it doesn't say one of the following. It's listed as if it's all of the above.
No, I know. And it's listed like all of the above. But what I'm saying to you is that it doesn't have to be. It's or. Think of or after each one of these things as opposed to and. If it was that is you gotta, because if it, I'm gonna tell you why. Because if it was and, it would have to be you attempted to strike a person and then you followed the person. And then you acted in a way that caused, and if you don't do all of those, then that means if you hit them but don't follow them and then act in a way, you still be not guilty. That's not the law. The law is if you strike another person or threaten to do so, that's harassment in the 2nd degree. Or if with the preamble, or if you, with the intent to annoy, harass, or whatever, follow a person in a public place. Like as you walking down and you come out of a club and some dude's, let me get your number. You're like, no. And that dude just starts following you everywhere you go. That's harassment. He didn't strike you, but they followed you. Or in the last one, act in a way that causes a person alarm or seriously annoys the person. Somebody comes up to you, you see these people melting down in public, and they start screaming at somebody, "Get out of here!" or whatever it is. The Karen situation. That would be aggravated harassment. In the Karen situation. Yeah, because it's now, hey, look, I'm walking around, you come up here and you're confronting me and you're doing it, and I'm trying to get away, and you keep blocking my path. Right. You are acting in a way that causes me alarm. But you didn't strike me and you didn't follow me.
And that's fine. I agree with you, but then why not read that like you just did? Or. Why completely eliminate it? I feel like they did that because if the jury saw those 2 other bullet points, even with the ors, they would not have gotten him for the fourth charge.
But the problem becomes the jury would then be able to, if they heard these other grounds, they would be given grounds to convict the defendant that were not charged in the charging document. If the charging document alleged that he did all three of these things in separate charges, or even in the same charge, I don't even care. If he was charged with doing all of these things laid out in here, then the jury should have been charged about that. But because he was only charged with doing the first one and not the other ones, the court was not authorized to give the jury another reason to convict him. Because they could have still said, well, you know, we do know he did this when he threw her back in the car. That's what we think is harassment. But it's like, I wasn't charged with that. I was charged with striking. I would say this, the defense was still entitled to tell the jury that these other things happen. Or at least in Georgia, it's been a while in New York. But you can basically say it's against the law for you to strike or harass. So they could have brought it in with the cops. They could have brought it in. You know, were you going to charge her for aggravated harassment? Yeah, she struck him. Yeah, she followed him for $5. That's against the law, isn't it? Yeah, they could have done those things. They could have brought that out and then had her to basically say, yeah, I did break the law against him because you did this thing, and then argued in closing. This is harassment. And the part about strike another person or attempt to threaten to do so, but it says with the intention to harass, annoy, or alarm a person. And the point being, he did these. You have to conclude it was to harass or annoy or alarm. But if he did it to get her off of him, even if that harassed, even if that annoyed them, that ain't a crime. Because every criminal resistance. But
that's why I feel like they misunderstood it, because he reread it to them again.
Right.
And they still got him for that. And that's not what happened.
And that would be the basis.
The video again, and first he reread the instruction. Then he let them watch the video. Then he had the stenographer read that little blurb about the ice and the finger. And I just don't think they understood it.
But but this is a violation. I will tell you that I'm not even worried about that one. I mean, if a violation is like so low,
that's a ticket. It's like a ticket.
Yeah. You're not even punishable by jail time. So on that one, I would still have gone. I think that the on appeal, they might argue, or the court could conclude that based on the evidence, that the evidence was insufficient. Like you didn't have enough evidence to show, annoy, harass, or alarm a person, because but it depends on what they are relying upon. If that was based on what happened in the car, the court could say, well, we don't think that this is what the harassment law was meant to cover. And under these facts, the undisputed facts, according to the witness. So the witness says, I was doing this and I was grabbing his phone when he pushed me off. Well, you know, do we think that reacting to someone attacking you is harassment? No, we don't. So the court on appeal, when it considers the sufficiency of the evidence, will not consider this in a vacuum. They will, but they're not going to substitute their opinions on credibility for the jury. And they're going to say, if from the evidence that did come out, they think it's reasonable for a jury to conclude that conduct could be annoying, harassing, or alarming, then it will stand on sufficiency. But if they kind of go under the facts that came out, and there are no other facts, there's no dispute, this is what everybody agrees happened, that ain't harassment. And if that's the case, then it'll get reversed on sufficiency of the evidence. The one he has to worry about is he was convicted. What was the second charge? It was aggravated harassment in the second degree?
The second one was assault in the third degree, recklessly causing physical injury.
Okay.
That, I think, was what they claim happened in the car with the finger. But I personally believe her finger got hurt one of those two times she grabbed his coat. That's why it was limited to just that one finger, and her whole hand wasn't bruised.
I think that, or in the ear, but I think again, the question will come down to sufficiency on that one. Like, did you all have sufficient facts for the jury to conclude that it occurred there?
Right.
In New York,
and
the New York
appellate court is very
New York appellate courts. When I was in New York, they really read the law, and the distinction. I'm gonna compare New York to Georgia. In Georgia, if it's somewhere in the neighborhood, you're not
we'll just throw the dart at it. If it wherever it sticks, that's where it's going.
The jury could have seen that. The jury could have reached that conclusion from these facts, and that's going to happen. I mean, I have gotten the case reversed on sufficiency, but it was really on a technical point that I only raised in a footnote. And that was the reason. I'm like, wow, the footnote won the case for me on appeal?
Right.
Okay. You know, but hey, I'll take the win. Yeah, but other than that, New York courts will really parse it and just go, do we think under the agreed upon facts where, and since, because he didn't testify. No, wait, he didn't testify, did he?
No, he didn't. He didn't have to. I mean,
no, he didn't testify because I was thinking it was something else. It was a press conference. He didn't testify. So the only version of facts that came out was from the police telling us what the woman said and the woman telling us what she told the police and the video. If in that it does it, the court says under this scenario, that could not be assault, then he walks again on sufficiency. So sufficiency of the evidence, unlike many cases where you kind of go, man, you don't really have much hope on sufficiency. I mean, as long as somebody said you shot him, you punched him, you hit him, they probably going to win. But in the context of this, where we have the so-called victim agreeing, oh, I did attack them first. I did grab them. They were trying to get their phone away from me. They were resisting me. I did chase them down and they did try to get away from me. For you to go through and start trying to slice it in, that the court might say, no, we're going to look at this, how it looked at. And based on that uncontradicted testimony, or even contradict, doesn't even matter. Based on that, that does not constitute, this is what the law was not intended to punish. It is not intended to punish the recipient of an assault from repelling their attacker. We cannot say that. Now, if they did, now they might say, well, he was extreme, he was whatever, but it's like, let's put it in the context though. Let's see how it happened. Again, you turn around and you punch her, break her eye socket, you probably going down anyway.
And he did not. He literally turned around, yanked her off of his coat and ran and stayed in a hotel.
So if you're using soft hands, as the police call it, that's what they'll say soft hand techniques. I grabbed, I pushed, I did all I could to avoid having to punch this person. Now that probably would have been something that could have certainly come out as well, with the police in terms of asking them about different techniques, what's soft hands, what's hard hands, and then going through. So this would, as a law enforcement maneuver, this would be soft hands. All right. And so when someone is, again, that's kind of the way that you develop it and you hope to get all of that in. But the appellate court may still say, based on what we have, I don't know, that's enough.
So they're basically going to have to appeal on multiple bullet points, not just relying on one thing.
Oh, absolutely. Let me tell you right now, as one who has done appeals and the ones I've won, well, I won most of my appeals actually, but whether I was a prosecutor doing the defense of the appeal or the defense lawyer now appealing, you raise everything. You put it all in there. I mean, you put everything in there that you can, because I've even had the court say, counsel raises a multiple number of grounds, however, and they focus on the one. I'm fine with that, but you never know if there's some judge up there who has some pet issue that's been bothering them and they're just looking for a case to make a point on. And you're like, hey, I might be that case. And if I raise some little nuance of the law that the judge is like, dang, that's what I've been looking for. Because I've always had a problem with that. Suddenly you got something. You gain a friend, you gain some ground. You never know what you get. So how much you want? How much money do you want? I want all the money. What am I gonna give you? All of it. How much are you gonna give me? I'll take what you give me, but I want it all.
I'm gonna aim high, and then we'll just work our way through the different. Yeah.
Because you only have one. Because you only get to do it one time. I mean,
one time. Right.
If I only get one pass at this, I'm bringing a bucket. How much water you want? As much water as I can carry. And I'm taking a big jug and I'm scooping. Kirby, you're being greedy, bro. I only get to come by here once.
One time. Therefore,
I'm taking my best shot, and I'm gonna make it good. And on the big issue, but you lead with the big strong stuff, and then you kind of spend less time on the smaller ones, and you just kind of those are like at the end of the brief. Yeah, it's like a paragraph where you just kind of write on it. And it's kind of like I put aside all my pros, and I'm just doing a paragraph and just letting it ride on that. But you put everything
in there. Now, in closing, so we win the appeal. What are the two options now? We get everything dropped and live on, or do we get it retried. Like, I don't know if we want to get it retried.
It depends.
So it's always going to result in a retry? Only
if the reversal was for anything other than the sufficiency of the evidence, you will get a retrial. Meaning if they say, only on the stuff he got acquitted on, he's not going to have to face trial again. The jury found you not guilty, they can't bring it in. So just on the things that remain, just those two charges, you can be, if they say the evidence was insufficient, no. If they say that there was some error that affected the confidence in the outcome, that is, there was some violation of due process that makes us question whether the process was done properly so that we can have confidence in the outcome. If they determine that, then you try it again, or you work out a deal. Now, I certainly think that I know why the prosecution would not want to work out a deal, which is just simply, hey, look, we got all the stuff that came in. We don't want these women's groups and domestic violence groups, all these people on our back, because we don't want all of them, because even though it happened to somebody else, has no bearing whether it happened to this person, but those people are going to still chime in and they vote so I don't want that. So the prosecution is probably going to go, you can't lose as a prosecutor by putting somebody on trial. Even if they get found not guilty. Hey, nobody's ever lost a job for being soft on crime. I mean, for being hard on crime or hard on perceived crime. Nobody lost their job with the Central Park wilding case and all that. Did no prosecutor lose their job? So my point is, you can't lose on that end as a government. So they have no reason to not charge him. They might run into the public going, is it worth a trial again? Do you want to spend this time, this money that goes into the prosecution?
And they won't find another impartial jury unless they go up to Montreal, like Plattsburgh. Because where are you going to find an impartial jury in New York City?
Hey, look, it don't even matter at this point. What you got to find is you got those transcripts out there, and the question for the prosecution is, are your witnesses going to say the same thing again? And from the defense perspective, I now know what you came with. I know what you got. I know I had a time to go through this whole case and think, you know what I should have done? You know, when you go, I zigged when I should have zagged. Well, now you get all that transcript and you can go back in and say, let me bring this in. Maybe I want to bring in my own expert at this point to talk about something. Maybe I want to bring in a use of force expert to talk about use of force. Maybe I mean, you just don't know what you want to bring in at that point to try to.
And they might even steal some of the prosecution's witnesses, because on Monday of this week, not Monday of last week, because this Monday was the verdict. The prior Monday, every single prosecution witness testified for the defense. Every one of them. And I thought for sure that day would have been the doubt for all 4 charges. The limousine driver, he was a prosecution witness. He said that the girl was the aggressor and that she was doing everything and he was doing nothing. The people she went to the club with, everybody that was a prosecution witness Monday before last testified on behalf of the defense. They gave the defense everything.
Why didn't the defense, and I'm curious about this, is why they didn't bring it out on cross-examination of those witnesses beforehand?
They didn't need to, because those witnesses, every question that the prosecution asked on direct backfired on them. So by the time cross came, they only had 2 questions to ask them, if that, and then they rested with the witness.
Yeah, I mean, I've done that before.
Because there was nothing else they could have said, because they said everything in favor of the defense.
So the question becomes, well, that's okay, recalling them. So they really didn't help when the prosecutor called them. And I know I'm talking like I got an accent. Well, they didn't help when the prosecutor called them. And they also didn't help, and they helped more for the defense when the defense called them. I get it. And I have recalled witnesses before, and it's been very successful. But I think that they're... On a retrial, I just think he has a much better chance. He just has a much better chance. And quite honestly, I think a lot of the evidence that came out, I don't even know why he's, all these people are dumping him. Because I'm like, we've seen the evidence. If you want to say it, I know they talk about history. He's had all this other stuff. There's been no charges.
But he didn't, though. They didn't bring any of those witnesses, any of the previous girlfriends, none of the people that he worked with, nobody that he went to Yale with. So those people don't exist.
No, that's what I'm saying. I'm talking about for the purposes of him getting another, getting back in the Marvel, because I happen to like his acting.
Me too. I'm a fan. I've told people before, I'm a fan.
Yeah. You're a fan?
Oh, yeah. I love his work, and he's only done about 13
I had never heard of him
things.
before he did his SNL thing. I didn't know who he was. But Yeah, he was great on SNL. So then I watched him on the Marvel movies and all that stuff, and the Loki season. What I loved him in Loki actually. But my point,
you got to see Lovecraft Country. Very good.
I think in light of the nature of the evidence, I'm going to watch that next. But I think in light of the way the evidence came out, leaving this trial, I think that it is beneficial for him because it's not like it didn't come out like it was alleged to have occurred on the front end. The front end, it was like he's an abusive, violent, controlling, possessive man. He slapped her around. He made all these things. Don't tell, whatever. Then you find out, no, you were drunk and you attacked this man. And yeah, you got hurt. He might be a complete jerk, and I get it. But a jerk and a criminal,
you can't get arrested for being a jerk, right?
Yeah, you really can't get arrested for being a jerk. And
we're all a jerk sometimes. I'm the biggest jerk ever.
Alex Baldwin is a huge jerk. I mean, I think
we have the same birthday. We have the same birthday, so I totally get his jerkiness because I can be that level of jerk if you get me to that point. So if that's the point, I should have been locked up many years ago.
Exactly. And I enjoy his work. I really do. I love him on 30.
Because we're great people until you piss us off.
Exactly. You're great until you get mad. But then the amazing part is, I think that because of the whole woke part, that's what's really like, oh, we got to separate the cover, I'm like, hold on, man. No, you don't. Because the way this came out, let's be real, this could happen to anybody. I mean, if you find that I think he did that, this could happen to anybody. You in a bad relationship.
It could happen to you, Kirby. It could happen to you. And that's really what's bothering me is that this something so simple, something that's an everyday occurrence for most of us. Not every day, but like an everyday kind of scenario could land you in your whole life being ruined.
Absolutely. And particularly when you have that bias in terms of how it goes. That's why I tell people I have the benefit of law and the benefit of knowledge. And I actually had a friend who had some issues with somebody in their life. And I was in court on like Easter morning at a bond hearing for them when I was getting them bonded out because they hired me as their lawyer to defend them in the case. And it was funny because I said the situation that you were going through, I was going through. And I thought to myself, you know what? I could really see myself putting hands on this person. And I'm a non-violent person. You have to know. I really am.
But everybody has that breaking point.
Right. And they had that breaking point. And I said to them, you know what? Because I saw that you and I are so similar and you broke and I see what happened to you, it made me reassess where I was. And I just had to know, you know what? I got to just disengage. When you say something, I disengage. I walk away. I leave things unsaid because I see how you got there, which is the same. You walked the same path I would have walked. In fact, we were walking that path together. And I realized you broke before I broke, and I had to think about it. But I had the benefit of seeing it happen to other people in real time and have to be there and then just go, all right, Kirby, I know how I am. And I also find out I'm neurodivergent. So I know how I can separate and kind of think things through. I'm learning all that now. And I'm like, so I have that benefit. But not everybody has that benefit. And then it's just people react. I've seen people react angrily and snap. And you go, bro, you really snap. And they go, I know. And I was wrong for that. But here's what the cause was. But in this situation, this is not even a case of snapping. I was wrong for that. This is a situation of, no, this was a altercation where I was a victim.
Right. And I'm trying to get away. I'm trying to get away and you won't let me get away. I'm trying to keep you away from me and you will not go away. Like,
because I recognize the bad parts. I recognize that.
Right. I recognize that I can lose it and really hurt you. I'm trying to get away from you. Sit back in the car. Go. Leave me alone. Get off my jacket. I'm running. You ran after me. You caught up to me. Got me back in the car. Ripped the buttons off my jacket. The second time, I run out of the car again. You called me 32 times.
Don't say you were afraid of me when you came to me when I was in the state of mind that you claimed to be terrified of. You know what I mean?
Wouldn't leave my house. I did not come home that night. And I texted you, leave my keys. And you were still there when I got home 12 hours later.
So I think that those are things that undermine her claim. Because I'm like, if you say every time he gets mad, I'm scared of him. Was he mad that day? Well, yeah, he was furious. And you was attacking him. So you can't tell me you're scared of this man or this person because you kept on when they were at the state. When the Hulk turned to the Hulk, you were still spitting in his face.
It kept going. And then
I don't
get
believe
this.
that you were scared of the Hulk.
After she came back from the hospital, because they had to take her in because he initially called the police thinking that she tried to commit suicide. So because he said that, they had to take her into the hospital to do an assessment. She came back to his house after the hospital visit. And her friend that helped her pack, because the next day she was going to London anyway, her friend that helped her pack said he kept trying to get her to leave, and he could not confirm or deny that she left because he ended up having to go after he helped her pack, and she still stayed in the place.
By the way, that'd be trespass. Just want to point that out. If he said don't go into place, that's kind of.
He said leave my keys. He said, "Did you leave my keys?"
Now, albeit arguably, if they were living together, she could have been categorized as a tenant, so it didn't justify him. You have to go through the legal process to get her out.
Well, in New York, it's a nightmare. Landlord-tenant law in New York is an absolute nightmare.
Right.
But landlord-tenant attorneys, and I was like baffled by how these people wrote out leases without paying for months.
Years. And look, I tell you, I just didn't have it in me to do that kind of work on either side. But because I felt for the landlords, because we want you to own an office complex, and I'm just telling you, man, it's like, bro, somebody got to pay this mortgage, and if y'all ain't paying, we paying.
Terrible. You have to be wealthy to be a landlord in New York.
Yes, you do.
I was one in Georgia, and they don't play. They send SWAT practically to get them out after the eviction day passes. But
yes,
New York is crazy. I've had cops come 6 deep for some of my tenants, but
they roll
that
but
wouldn't leave. Yeah, but
I think that he has some, so that wouldn't have been a good grounds. But I still think that the overall, you're undercutting, and it's sometimes just it's when it comes to building a case, in a case like this, sometimes, and if he gets a reversal, it'll illustrate the point I'm trying to point out, which is that sometimes you attack it on the big points, which is what they seem to have done. You just hit the big points and you go, clearly, you, the jury, get this. But when you're going against some inherent bias, race, size, gender biases, and the like, you got to sometimes get down and really start going. I got to point to you all the internal inconsistencies, which you spent time cross-examining. Like she did a great job with the finger. I think it was like 60 instances of, in this where you wipe your hand behind. She really broke that down.
Plenty of photographic and video evidence that she was not injured.
But the point that I'm making is the photograph and video evidence is great, but you're only illustrating one point. You just keep showing. You prove that one point 1,000 times. You win on that point. But there's a bigger picture. So now on a retrial, you can kind of go in there and say, I see now I got to go through. How do you keep telling me you scared of this man and yet you provoked him? How do you scared this man and you attacked him? How do you scared of this man and you wouldn't leave the place where you knew he was coming back to? And you got to start going through all of these things so that the jury kind of goes, huh. And you're just hoping for somebody, for that one little bit of rationality to break through the emotional component of big man, little woman, she's hurt. Come on, guy. That could be my daughter. Don't forget
the British accent. We're taught in marketing that British accents, they do something to the consumer. So the British accent probably reeled them in too.
Oh yeah, that British accent is definitely I always wonder how can everybody that goes into space in science fiction, unless is British,
British is always the go-to accent. Even if it's an African movie, everybody has a British accent. So
the 10 Commandments, not a British person
everybody
there.
British in the 10 Commandments, right? I thought they were Hebrew.
Except for Edward G. Robinson, who I really loved in that movie, because I'm like, give me an American guy. Come on, guy. What do you say? And I'm like, that's an American guy, but I can go with that, man. He sounds like a thug. I can get with that as opposed to, all this British stuff. Give me some real stuff. So I get that. But I think that sometimes you got to just go, all right, I really had to go down into the nuances and just connect. And maybe one juror kind of goes, yeah, because just like that juror dropped her head on that when they had that read back, the same time, it could have been, they could have read back, did you go back to his apartment? Yeah. How many times did he ask you to leave? Several times. And they kind of go, yeah, you know what? That did actually come out. And so I have a hard time believing. But domestic violence cases are, well, I'll say this. The one thing about a jury, and we say it in the practice of law, you never know what a jury's going to do. You really don't. I mean, because OJ, that was not guilty. You know, this guy, guilty. I've seen a lot of trials where what was that? What was the lady accused of killing her baby? Man, I was on Nancy Grace all the time. Drawing a bank, man. The woman who was accused of killing her baby and she blamed her dad for it. It was drawing a blank.
Oh, Casey Anthony.
Yeah, Casey Anthony.
That was Florida.
Yeah, but that's what I'm saying. But nobody would have foreseen that. You know what I mean? Mm-hmm. So once you just start breaking it down, you really kind of go, I don't know what the jury's going to do. So I just got to know what to appeal to. And sometimes it works. And other times it's like, you know, throwing chicken bones out and trying to figure out. I mean, I think juries tend to get it right. But other times you're like, I don't know what y'all did in the back because I don't know how y'all reached that.
I had concerns about that jury. As soon as I saw them walk out, I was like, oh, man. Because half of them were under the age of 30. And I'm like, they don't even have any life experience. And they clearly were not ladies' men. The guys, you can clearly tell that they are not the type of dudes that pull chicks and are used to relationships. They probably had 1-2 girlfriends their whole lives. Very young. No, very young. And I mean, you know, in our generation, you know, 20, 19, 20, 21, 22, you're married, you have your degrees, you're on the path of your career. These days, 30 years old is like 18 2.0. You know, they have no sense of responsibility. No sense of responsibility. They don't get a lot of things. They don't see having career aspirations or being in your career as having been a benchmark. They're just starting. You know what I mean? It's a big difference.
Everybody, they were justified in this. You're always justified in being offended. And if you're a victim, you were a victim. And it's like, well, not everybody who claims to be a victim is one. And not everybody who is a victim
we're in that participation. We're in the oppression Olympics era, and we're in the participation trophy era. Because you exist, you should be rewarded. Because you said you're offended by something, then we should just stop what we're doing and bow down to your offense. You know what I mean? It's crazy. And I think that was the jury. That was that jury of, with the exception of maybe 2-3 of them, that appeal to that type of, you know, oppression Olympics mentality. And that's why we're here. So
and here we sit, and it is the nature. It is how it is. I you know, don't get it. It'd be a whole different video on this one. You know, 2 people talk about this generation.
Yeah, exactly. Lord help us. Do not put them on a jury. In other words. But thank you. I appreciate you sitting with me. Everybody follow Kirby on Instagram, the official Kirby Jr. JR on Instagram. And if you are in the Atlanta area and you need attorneys for criminal defense, personal injury, it's Clements lawgroup.com. That's CLEMENTS law LAW group GROUP.com. They are in Atlanta, Georgia, and you know that's where they practice. So if you're in Atlanta metro area, that's where they are. And thank you, Kirby. I appreciate you so much. This was awesome. I pray that the viewers got a better idea of what Jonathan's rights are and what their rights are if they find themselves snatching a cell phone from a crazy ex-girlfriend.
Don't do it.
You know, either don't do it or call the cops immediately as soon as she snatches your phone. So then that way you're protected and you don't have to end up in this situation. But again, hindsight is 2020. You know, we can Monday morning quarterback all day, every day. But this is why I did this, so that now we can be armed with information. We can think and be like, whoa, this just happened to Jonathan Majors. Let me, you know. And I pray, this could be you. This could be you. And this is something, like I said, that's an everyday thing, something nobody ever thinks of until it gets to this point. And we just hope that this doesn't happen again and that he can appeal and he is successful. Thank you, Kirby.
No
Thank you guys for watching. And he'll be back again. You'll be back again, Kirby.
I will be back.
And have a Merry Christmas and a Happy New Year if we don't speak before then.
All right. You too.
Bye-bye. Okay, bye-bye.